Defensive homicide is an alternative offence to murder, and what it means is that where someone has killed with a genuine belief that they were acting in self-defence, but it's found that that belief was unreasonable, they can be convicted of defensive homicide as opposed to the more serious offence of murder. Defensive homicide was brought in November 2005 at the same time that the Victorian Government abolished the very controversial defence of provocation. And it was brought in not as a replacement for provocation, but specifically to cater to the context of persons who killed in response to prolonged family violence. Yet what we've seen in the years since it's been brought in is that it has been used predominantly by men who have killed other men, not in the context of family violence. So it's operating in a very unintended way, and it does raise question about why these cases are being treated as less serious than murder, and what that means in terms of the criminal law's categorisation of different forms of culpability. The Department of Justice report recommends that defensive homicide be abolished as an alternative offence to murder, and this is an incredibly welcomed step forward for the law of homicide in Victoria, which has been continually plagued by controversy since 2005 when defensive homicide was brought in. What it does mean is that now people who kill with an intention to kill will be labelled as murderers, and then the differences in culpability can be taken into consideration at sentencing. Victoria is very unique in that we are the only jurisdiction in Australia that has an alternative offence of defensive homicide. It is quite similar to excessive self-defence, which isn't available as a partial defence in some other jurisdictions, but by abolishing defensive homicide, we would actually bring the Victorian law of homicide more in line with other Australian jurisdictions.